Okay, first of all, so good evening to the class. Good evening, everyone. Can you hear me? So please tell me whether you can hear me well. Thank you very much. Now we will start the lecture now. So first of all, just housekeeping matter. It's our fifth lesson. In the last lecture we have done part one of case law. Now we go to part two. But usually below you have some follow-up matter, some follow-up questions. Some students have questions, so I will respond to the question. Okay. Thank you very much. So in case of anything wrong, don't hesitate to tell me. Okay. For this lecture, we'll cover part two of Chapter 5 case law. But before that, I will respond to some question asked by student. And also we'll do some exercise. In the second part, I think we will start Chapter 6 legislation. So the first part of Chapter 6 is about passing of legislation. So in the next lesson, this Thursday, we'll finish Chapter 6. We'll do some exercise on precedent, so see whether you can understand those exercise. You can record what you have learned in the last lesson. So a student asked me a question on the case of Yun Sek On. Please try to recall what you have learned in the last lesson. For the case of Yun Sek On, Mr. Yun was sentenced to imprisonment. A total year of imprisonment should be 4 years of imprisonment. So he appealed on the ground that Section 57 said that the maximum should be 3 years. So we have two possible explanation to this, or interpretation to this Section 57. So it's so you may recall the case of Yun Sek On. So it's the exercise of Yun Sek, is the case of Yun Sek On. Okay, he was sentenced to imprisonment by two separate magistrates. The total term of imprisonment should be 4 years. It should exceed the 3-year limit under the proviso to Section 57 of the magistrate ordinance. So we have two interpretations. For the two possible interpretations, some students do not quite understand what is meant by A and B. A means that is the restriction applied to the same magistrate. So what does it mean? It means that if, for example, in Magistrate Chen impose 2 years for count 1 and 2 years for count 2, is something not allowed. Is the interpretation A. Okay? So the A said that so the restriction of 3 years only apply to the same magistrate, 同一個法官。Okay? So it means that if the sentences are made by the same magistrate, so of course it's not allowed. So I think everyone agree with A, but the difference is that whether the restriction only apply to the same magistrate or whether it also apply to two different magistrates. For B side, they say that even though the two sentences are made by 2 or more magistrates, for example, Magistrate Chen and also Magistrate Wong, it's also not allowed. It's the interpretation of B. Okay? So B side says that even though the two sentences are made by two separate, two different magistrates, it's also not allowed. So it's the interpretation. Is the B interpretation. The outcome is that A is followed. So at the end of the day, the court held that A should be the correct interpretation of Section 57. Okay? The restriction of 3 years only apply to the same magistrate. If the two sentences are made by two different magistrates, is something allowed. Okay? So it's the interpretation of A. Okay, so A at the end of the day, A was preferred by the judge. Okay? Of course, many students will find the case a little bit difficult. But don't worry, I think it's something very lecture because law is something so new to all of you. So many students have not heard of those legal concepts, so you have to pay a lot of attention, a lot of effort in understanding the law. And so recently, over the weekend, I was marking the answer script of some student. So for the exam answer script, I know some students, they have misunderstanding on so many points. But I think we need more effort, or for me, I have to explain the law in a easier way. So I think it's still too difficult to some students. Right? So for A and B, at the end of the day, A was preferred. Why? Because of this case. This is a house of law case. At that time, all the court in Hong Kong will follow a house of law case. It's the superstar, right? So all the judges will follow a house of law case in the 80s of the last century. Now we can do some exercise on the doctrine of person. See whether you can recall what you have learned. So person case is a case in the past. For example, CFA 2008, CA 2004, CFI 2000. All cases were made in the past. It was something in the past, but they are still very useful. So from time to time, when you study contract law, you may study a case in the 19th century or 18th century or even 17th century. Okay? So the instant case is the case the court is hearing today. For example, today is 10th of September. Of course, today is 15th of September. So it's the case the court is hearing today. For example, 10th of September 2020. So vertical, very simple. It's just lower court and upper court. Okay, lower court or higher court. So of course everyone will know a lower court has to follow the case of a higher court. Okay, it does not mean that the higher court is giving an instruction to the lower court. The higher court case, the person case may be in the year 2000, 2005. But still, the lower court has to follow the decision made by the higher court in the past. The issue, please note that the issue is in a question form. The answer is yes. Okay. The issue is when the lower court is hearing the instant case. If the counsel say a case made by the high court, whether the lower court has to follow the higher court, okay? The decision of the high court. Of course, the answer is yes. So vertical stare decisis is quite simple because it's just a simple rule. Lower court has to follow the decision of the high court. High court's decision is binding on lower court. Horizontal is more difficult, and also please bear in mind, horizontal means whether a court has to follow its own decision in the past. Is the meaning of horizontal. So many students have the wrong understanding. Many students say that under horizontal stare decisis, a court has to follow its own decision, or a court does not have to follow its own decision. Both statements are incorrect. Why? Because whether a court has to follow its own decision, it depends on which court you are talking about. So CFA, CA, and also CFI, all of them have different rules. Okay? So we have to consider them one by one. Don't think that all the court use the same rule. The rules are different for different court. Okay? Different court will have different rules. Don't think that all the court have the same legal principle. So for example, whether for example, so if the CFI is hearing a case today, so a counsel say a CFI case. Okay, so whether CFI has to follow its own case is the issue of horizontal stare decisis. The two cases they are made by the same level of court or same court. Okay, so it's the meaning of horizontal stare decisis. So cases are person. It can be either binding or persuasive. Binding means that you have to follow. You don't have any choice. Persuasive only means you can either follow or not to follow. Of course, most people will follow, okay? Especially if it's quite persuasive case, a very clear case. So usually it will be highly persuasive. But whether you will follow is up to you. So you can choose not to follow for a persuasive case. So you don't have to follow. But if the case is binding, you have to follow. Now we are going to exercise. So if the instant case is CFI, if the person, if the lawyer say a CFA case, binding or not binding? The first one. Binding or not binding? Very good. It should be, okay, it should be binding. So, the first one, it should be binding. Number two, CFI. So if the person case is CA, binding or not binding? Still binding. Okay. So for the second situation, it's still binding. Okay. So if the person case is a district court case, is it binding or not binding? Not binding. Very good. Not binding. So the third one, so it will be not binding. Not binding, right? So it will not be binding because district court is lower than CFI. So in the judicial hierarchy, so it's lower than CFI. So usually you don't have to follow a decision made by the lower court, but you have to follow the decision made by the higher court. Okay? How about CFI? So if CA is hearing a case, if the person is from CFI, do you have to follow? Is it binding or not binding? Again, so again is not binding. So a vertical star rate decisis is very easy. As long as you know the court hierarchy, so it will be very easy for you to know the answer. Okay, so you have to follow a decision made by the high court, but you don't have to follow the decision made by the lower court. Okay, so it's the simple rule. Now we go to another one. CFA. So if the instant case is CFA, present case is also CFA. Binding or not binding? So for this one, binding or not binding? Some students say binding. In fact, it's not binding. So of course, we seldom use the term not binding. So we seldom say, oh no, CFA is not bound by its own case. So we usually will say, oh, CFA is not required to follow its own case. But this say is very exceptional, very sparingly. So CFA will only exercise this authority very sparingly. So it's very exceptional. It will be a very exceptional case if CFA does not follow its own case. Of course, usually we will not make it so simple. I will explain, I will emphasize. So it is very exceptional for CFA law to follow its own case. The reason is very simple. If CFA is bound by its own case, what will happen? It means that the case law will never change. Okay. So usually the judge in the highest court will develop the law. Sometimes they will depart from the old decision, just like House of Law. House of Law will develop the law. House of Law will make new decision. But so usually only the highest court, like CFA, no, in UK is House of Law or Court of Appeal. For the lower court, usually they are not allowed to do so. They have to follow the old case. Okay? So how about CA and CA? If the person is also if the person is also CA case, theoretically, so it's not binding. So sometimes you can say, oh, CA is bound by its own case, but subject to exception. In general, we can say that CA is bound by its own case. CA has to follow its own case, except so. But the general rule is subject to one exception. If the precedent case was plainly wrong, CA is not required to follow its own case. Of course, we have to understand the law. I think usually you have to explain the legal principle quite clearly. I think it's not a very good idea for you to just say, binding or not binding. How about CFI? Do you think CFI has to follow its own case? CFI. Very good. From CFI, the court is not required from CFI, for CFI and all the law court, including district court, magistrate, or tribunal, they are not required to follow their own decision. Okay, I mean that CFI is not required to follow a CFI case. District court is not required to follow a district court case. So it's the horizontal star rate decisions for CFI and also case court below. So starting from CFI, the court is not required to follow its own case. How about English case? For example, do you think CFA has to follow its own the decision of Privy Council or House of Lords? Binding or not binding? When CFA is hearing a case, if the council say a Privy Council case or House of Lords case, do you think CFA has to follow those cases? Very good. It should be not binding. It should be not binding. Even though Privy Council cases are from Hong Kong, they are binding on all the lower court in Hong Kong, but it will not be binding on CFA because CFA is at the same level of Privy Council. So CFA is not bound by the decision made by the Privy Council for appeal from Hong Kong. So it is not binding. But of course, CFA usually will follow those cases. How about CA, CFI, and district court? For Privy Council case, appeal from Hong Kong, do you think they are binding or not binding? For the second one. Alright, yeah, we go. It will be binding. For Privy Council cases for appeal from Hong Kong, it will be binding. Okay, so on CA, CFI, district court, and all the lower court. How about if the case is appeal from Australia? Do you think it will be binding on CA, CFI, and district court? Very good. So no, if the appeal was from Australia instead of Hong Kong, it will be not binding. Okay? It won't be binding. Right? How about House of Lords case? Do you think House of Lords case will be binding on CA, CFI, district court, or other lower court? Binding or not binding? House of Lords case. House of Lords case. House of Lords. The answer should be not binding. Even before 1997, it was not binding. Even before 1997, House of Lords case were not binding, but it was highly persuasive. So some legal scholar that said that it was virtually binding, even though legally speaking, it was not binding, but virtually, practically, it was binding before 1997. But of course, nowadays it will be less persuasive. So 9日前咧理論上就唔係 binding 嘅，但係當咗係 binding 嘅啦嘅。So because practically speaking really all judges will follow a House of Lords case before 1997. So it's what we have learned before. Consecutive and also concurrent. It will make a very different, right? Whether the sentences are consecutive or concurrent. So it's something extremely different. But usually, from concurrent, it was related to a single incident. For example, fighting in the bar. So the wrongdoer will be prosecuted for so many offenses, but all the offenses are related to the fighting incident. Okay? But for consecutive, usually they are separate incidents. So if someone was involved in fighting in 2 separate incidents, so the sentence will be consecutive instead of concurrent. Okay, so I think it's a very good example. I think hope all of you will can understand the legal rules. Don't confuse the rule. Because many students in the examination answer, sometimes they simply cannot distinguish the different position. Some people can't see this lesson. Why? It's not sharing to them. Why? So what do you mean? Scott Ricky Pope. Nothing is being shared. Maybe it needs to be wrote or something. I think they have to. I think don't know. Oh, maybe there may be some technical problem. I think they have to maybe a very practical solution is to switch off the computer and then try to reboot the computer again. But if you cannot see the lesson, okay? I think so you need to click the top right. So what does it mean? Allow everyone. Oh, there. Good. Oh, I see. Okay. So now you can see me. Okay. Any problem? I don't know why. I don't know. No. Okay. So thank you for telling me. So in case of anything wrong, so please let me know as quickly as possible. Now is the I think all of you have the answer to the case of insect on. Okay. So it's the reproduction of proviso to section 57. The substantive issue is whether under this section a magistrate may impose a sentence and order it to one consecutive with an earlier sentence imposed by another magistrate, whether the aggregate would exceed the limit of 3 years. So please we call it issue. Issue is the point of dispute. Many students, so after they have finished this module, they still do not know what's meant by issue. Issue is a point of dispute, 爭論點啊 okay? For example, whether the manufacturer owe any duty of care to the defendant, whether say the defendant have breached the duty towards the plaintiff, etc., etc. So it's the example of issue. So it must be in a question form or starting with whether or if. Okay. So the usual format is whether so and so. Whether Peter has breached the contract is the issue of the case. Okay. So you have to understand this concept because it's a very important concept in legal study. From time to time, if you're going to solve a problem, you have to spot the issue. Okay. So Usually you have to confine yourself to the important or to the relevant issue. Another, apart from substantive issue, means the issue on substantive law. Okay. So the other one is precedent issue. Precedent issue, because we have so many conflicting precedent or conflicting decision. So we have to decide which one we should follow. Okay. The outcome is appeal dispute. So if you have to answer the outcome, you only have to state the outcome. Sometimes you also mention the legal cause, but no need to explain the reason for the decision. So usually when I ask you the outcome, you just say, oh, appeal dismiss or appeal allow, or the defendant is found guilty, the defendant is found not guilty, etc., etc. So no need to explain the reason, because it will be duplicating. Usually the reason or the outcome will be the other part of the question. And so in the last lesson, you learned the 3 exceptions to the case Young and Bristol helping. So we have 3 exceptions, 1, 2, and 3. Okay. So it's the explanation of per incuriam. Per incuriam usually means that the court failed to consider something relevant. For example, a case or some legislation. So it's the meaning of per incuriam. Per incuriam is something. It's not something unusual. Because from time to time, sometimes one party, for example, the defendant, was not represented by any lawyer. So the argument in favor of the defendant was not so well researched. So we only have the argument of the plaintiff, but we don't have any argument in favor of the defendant. And also sometimes the lawyer, even though no, the party was were represented by lawyers, sometimes the lawyer did not do a good job. So he was very lazy, he did not do the research well. So some cases were overlooked by the judge, because the judge has to rely on the lawyer from time to time. Don't expect the judge will do the research by himself, because we have division of labor between the lawyer and the judge. Okay? Don't expect the judge will do everything. So it's the answer for the case of Yun Sek On. Now we will start part 2 of chapter 5. So in the case of Yun Sek On, you can extract the legal principle. Okay? So you can see the case of Yun Sek On. So after you have finished reading the case, so of course when you're reading the case, the facts in this case were not so relevant. It were not controversial. The facts were not disputed. So many students, so many people before they study law, they always think that the dispute is on fact. So we have 2 different types of dispute. So in a legal case, in a court case, in general, we have 2 major types of dispute. Dispute on fact and also dispute on law. So for example, so in a defamation case, so whether the defendant have made such a statement, so sometimes it's a dispute on fact. Sometimes the defendant will deny. The defendant will say, I have never made such a statement. Okay? So it's a dispute on fact. 事實嘅爭論。But in the classroom, usually we will focus on dispute on law. Dispute on law means that there were no dispute on fact. But what is the legal implication? What is the legal consequence? It's a dispute on law. We are disputing on the law. Okay? Disputing on law is not something, it's not a usual concept for most people. Most people only know that there will be dispute on fact. Most people do not know what is meant by dispute on law. But in the classroom, usually we are focusing on dispute on law. Okay? What does it mean? It means that the facts are given. So you only have to discuss the legal position. Okay, you don't have to find out the fact. All the facts are provided to you. Okay, you don't have to dispute the fact. So it's the reason why we call it dispute on law. So after reading the case of insect on, you can find out the legal principle. Okay, you can find the legal principle. So in fact, it's the legal principle. So in the headlook, in fact, you can find the legal principle, the underlying legal principle for the outcome of the case of insect on. Why? So why the appeal was dismissed? Why? Because the 3-year limit only applied to sentences passed by the same magistrate. Now the sentences were passed by 2 different magistrates. So it will not be subject to the 3-year limit under section 57. Okay, so it's the legal principle. So of course, for the party, they are more concerned with the outcome. For Mr. Yun, he's very concerned whether the appeal is dismissed or allowed. Okay, so it's a big concern to him. If the appeal is allowed, the sentence will be reduced from 4 years to 3 years. So it means that he only had to spend 3 years in the prison instead of 4 years. Of course, it will be make a big difference to him. But as a law student, as a lawyer, what should you do? You should know the legal principle. Why? Because the legal principle, after you have read this case, you can extract the legal principle for what purpose? To be used in the future. The case was in 1986. After this case, whenever we come to the same situation, we can simply apply this legal principle. The legal principle can be used in the future in all the similar cases. When we come across a similar situation, we can simply apply this legal principle. There's no need for the lawyer to do any more legal research. The legal principle is very clear, very simple, no need to argue, no need to dispute, no need to do any research in the future. Just follow this case. Okay? So I think it's very difficult for you to expect, even though this case was only made in the Court of Appeal, I think the CFA will also follow this legal principle. So no, you simply cannot find any reason why this legal principle is not followed in any court. Okay? So it's the importance of the underlying legal principle. So it's the reason why we always emphasize you have to extract the legal principle from the case. Don't just look at the outcome. The outcome is not so important. Right? The reasoning is more important. The reasoning for the outcome is more important than the outcome itself. Okay? For the outcome is not useful. No, when we say the appeal is dismissed, so no, you cannot. This outcome will be followed. Because in different cases, the situation is different. You simply cannot expect in all the appeal case they will be dismissed. Right? So the legal principle is more important than the outcome of the case. Now we know so the importance of the underlying legal principle. So in law it's called ratio decidendi. So it's the proposition of law. The underlying principle which form the authoritative element in any judicial decision. Some people call it a byproduct, 副产品, byproduct of the court decision. When the court has to make a decision whether the defendant is liable or not liable, whether the appeal is dismissed or allowed. So the court has to give the reason for the decision. The court cannot just say, oh, sorry, so your appeal is dismissed. Okay? So you won't get any compensation, you lose the case, you win the case, you can get 5 million. So the court has to explain the legal principle for the decision in a document called judgment. Okay? So for a lawyer, they will study a lot of judgment in order to extract the legal principle from the case. It's called reason for the decision or the principle of the case. For example, why the defendant was found guilty of theft, why the contract was found to be law binding. The court has to explain the reason for his decision. So the inside the judgment, there will be legal rules. So the job of the lawyer is to extract the legal rule. Why? Why he has to extract the legal rule? Because he will use the legal rule in all the similar cases in the future. Whenever we encounter a similar case, we will simply apply the legal rules. Okay? So it's the importance of precedent and decision. When we say we follow a precedent, so for example, in the case of Incheon, the outcome is the appellant, the appeal was dismissed. When we say we follow the case of Incheon, it does not mean that all the appeal will be dismissed. We just follow the legal rules for the case of Incheon. Okay? About how to find the ratio, how to extract the legal principle. So if you say try to extract some material, of course you do it in the factory or you do it in the laboratory. But in law, of course, we don't have to use the laboratory. We just extract the legal rules by ourselves. You don't have to use any machinery. So the answer is very simple. The ratio is generally found by analyzing the fact which the earlier court itself held to be material. A material in this context means relevant. A material fact. There are lots of facts. So for example, now you are already 40 years old, 30 years old. So you have a lot of information about yourself. Okay? But if you want to sue someone, the lawyer will ask you the facts about the accident. Okay? So all the facts about the accident are material, are relevant. Okay? So your hobby, your interest, what ball game you play is something immaterial. The opposite is immaterial, 無關. Material means relevant. Okay? So when you talk to a lawyer, you only have to tell him the material fact. Okay? What actually happened in the accident? What injury you have suffered? These are something material. Okay? So no need to tell him something immaterial. Okay? Because by doing so, you are simply wasting his time, and also you have to pay more money to the lawyer. The job, and also the job is done by the judge in the later case instead of judge of the earlier case. This is a very funny case. For example, when you say, if the instant case is today, so the lawyer cited a case in 1970. So the job to extract the legal principle of the 1970 case was done by the judge in the later case. So when you cite this case, the judge in the instant case will extract the ratio decidendi. So the job was not done by the judge in the 1970. Okay. So for the judge, when he prepared the judgment, he will not state the ratio very clearly. He will not use a paragraph with a heading or ratio. The ratio of this case is as follows. He will not use this kind of expression. Life will be much easier if the judge can state the ratio decidendi very clearly in his judgment. For example, if there's a paragraph with the heading of ratio decidendi and the judge say that the ratio of this case is as follows, of course, our life will be much easier. So it will be welcomed by most of the law students because they can save a lot of time in order to extract the ratio decidendi of a case. But of course, many students will say, why didn't the judge do the job? Okay, for example, when the judge in the 1970, when he made his decision, when he prepared the judgment, why didn't he make it very clear what the ratio was? Why didn't he do the job? It's a question always asked by student. First of all, we have some tips on finding the ratio. Find the judge decision in the case of, for example, whether the defendant is found guilty, not guilty, the appeal is dismissed, is the decision or outcome of the case. And then ask why that particular decision was the one the judge preferred instead of the defendant is found not guilty. So you have to compare the two possible outcomes. In a criminal case, the usual outcomes are either the defendant is found guilty or the defendant is found not guilty. These are the two possible outcomes. When the defendant is found guilty, you have to ask why he is found guilty instead of not found guilty instead of not guilty. So you have to compare these two possible decisions. First of all, so now I can give you a very simple gag. So now I will prepare a gag to illustrate the legal principle. So we call it ratio decidendi. So this time, so when I prepare this short note, I know we have a function called design. Okay, so I press the button, and now we have much better design instead of just typing the say the paragraph on the PowerPoint. First of all, so if I only tell you the underlying principle, many students will ask, why didn't the judge tell us the underlying principle, the ratio decidendi? Okay, for example, in legislation, so you see that in legislation we have so many legal rules. Okay, so in year one, so if the teacher asks you, do you prefer legislation? Which one will you prefer? Will you prefer legislation or case law? Most students will say, we prefer legislation. Why? Because for legislation, you don't have to extract the legal rules from the case. For case law, you have to go through the whole case and then you try to extract the ratio, the underlying legal principle is a very difficult job. But for legislation, all the rules are expressly written down, so it will be a much easier job. But the point is that if I only tell you the underlying principle, the legal rule, it's difficult for you to know what it actually means. If I do not tell you the case, if I just tell you the legal principle, sometimes it will be more difficult for you to understand what it actually means. Why? Because if I tell you the case with fact, it will be much easier for you to understand. So it is also the practice for many subjects like management. So for management, you do a lot of case study. By the case study, you can understand the management principle much more easier. If I only tell you the principle without telling you the case, it will be very difficult for you to understand the principle. For example, so we can use a very simple example. For example, teaching referral story. For example, if your mom tell you don't tell any lie, don't tell lie, right? So what's your response? Your reaction? Why? Why shouldn't I tell you any lie? Telling lie is something is not so bad. Why I should not tell any lie? If your mom only tell you don't tell any lie, okay? You do not quite understand what it means. So you cannot appreciate the reason why you should not tell any lie. Okay? So it's the reason why your mom tell you the story. The wolf is coming. In order to let you know why you should not tell lie, your mom will tell you the story. The wolf is coming. So after after your mom has told you this story, you will appreciate the teaching. You can understand the teaching. You can understand the reason why you should not tell lie. Because if you tell lie, no one will trust you again. Okay? This time you are fooling other people. In the future, next time no one will trust you. Okay? So it's the reason why you should not tell lie. Right? By listening to a story, so it will be easier for you to understand the teaching. Okay? Teaching of the story. Okay? After telling you the story, your mom also tell you the teaching. That's the ratio, that's the didnt of the story. Don't tell any lie, otherwise no one will trust you. If your mom does not tell you, sometimes if you are not so clever, sometimes you cannot appreciate the teaching of the story after you have, say, after your mom has told you the story. You may still not know what the teaching. Okay? Your mom does not tell you the teaching. You may have different feeling. For example, you say, oh, fooling other people is fun. I will do it to my friend. So it's telling lie is something so good. So when you were young, after the story is finished, usually your mom will tell you the teaching of the story. He will say, kids, so don't tell any lie. Okay? Just like this boy. He was lying. No one trusts him anymore. Okay? If you tell lie, everyone will know that you are unreliable, you are say dishonest. They will not trust you anymore. You will suffer in the future, so and so. So your mom is so afraid that you do not quite understand the teaching. He will tell you the teaching directly. Okay? Because she is so worried that you do not quite understand the teaching of the story. But when you are grown up, when you are getting older, when you are already an adult, when you are already 25 years old, 30 years old, after watching a movie. Okay, for example, this movie. So after you have watched this movie, so would you like people tell you the teaching of the movie? When you get older, would you like someone to tell you the teaching of the movie? So at the end of the movie, so there's some subtitle to say that, oh, the teaching of this story is love your neighbor. Be faithful to them. Don't trust a bad guy. Okay? So do you like it? Of course, no one will like it. Most people will think it's something so annoying. Okay? How come? You have to tell me. Okay? So it's the reason why the judge does not tell you the ratio. Why the judge does not tell you the ratio? Why? This is the reason why the judge likes you to extract the ratio. Just like the producer of the movie. He wants you to find out the underlying teaching of the ratio of the movie. It's up to you. Okay. So no one will tell you expressly because it's something so frustrating, so annoying. If the judge use a heading in the judgment, for example, so ratio of the case is as follow, what will happen? No one will bother to read the whole judgment. They just focus on that paragraph. If the judgment is 20 pages, so the judge at the end of the judgment, there's a paragraph with the heading ratio of the case. For most lazy law students, they will skip most part of the judgment. They just look at the ratio of the case. Okay? So it's highly undesirable. The judge always wants you to go through the whole judgment instead of just focusing on the paragraph with the ratio that's didnt. So it's the reason why the judge does not tell you the ratio. So formulation of the ratio. Ratio is not only confined to the fact of the particular case. So the ratio is expressed as a statement of law at a higher level of generality. It means that we'll expand the scope of the ratio. So it's not confined to that particular case. So it is more general than the facts of a particular case. It may be level or wide. Sometimes the ratio is level, sometimes wider. Some ratio is leveler. So it means that the court use a level approach. Because the judge sometimes is so afraid of the possible outcome, the possible impact. So he try to level down the scope of the ratio. He does not want the ratio will affect so many people. Some judge will use a wider ratio. A wider ratio will affect more people, will cover more people, will cover more situations, okay? Which will result in a more extensive legal So formulation of the ratio, it can be illustrated by case. Donald, Hill, and Stevens. Donald, Hill, and Stevens is the most important case in modern tort law. Now we please go to the case will be on page 8A of the workbook. Now please go to slide 14. I will skip the part on obit. Please, now we will go skip the part on obiter and some other legal concept. Please go to page slide 12. Slide 12. Okay. We are going to see a case, or the case is a landmark case of modern tort law. So it's the landmark case for lecture. We call it case by case development. Of course, before the case of Donald, there were already some cases relating, talking about lecture. The case is called Donald, Hill, and Stevens. Of course, you can also see this case in YouTube. You may type this the name of the case on YouTube, and you can find a very funny case. Facts of Donald Hill. The plaintiff's friend bought a bottle of ginger beer and passed to the plaintiff. The plaintiff drank the ginger beer and found a decomposed snail fall out of the bottle. So it's what happened in the case of Donald, Hill, and Stevens. No, we have the manufacturer of ginger beer. He sold the ginger beer to the seller. In this case, it was the pub. The pub was the buyer of the of the ginger beer from the manufacturer. Of course, the pub also sold the ginger beer to all the customers. So one day, Donald Hill's friend and Donald Hill went to a pub, a cafe, and they consume. They bought a bottle of ginger beer, 2 bottles of ginger beer, okay, from the cafe, okay. So what happened is that you find that there was contract between the manufacturer and the seller. There was also contract between the seller and Donald Hill, Donald Hill's friend. But there was no contract between the seller and Mrs. Donald Hill. Okay, because Donald Hill did not buy the ginger beer from the seller. It was Donald Hill's friend who bought the ginger beer. Okay. Donald Hill's friend invited Mrs. Donald Hill to drink the ginger beer. Of course, Donald Hill was very happy. Okay. But when he was drinking the ginger beer, he found a decomposed snail. 腐爛咗個鍋, right? So he was sick, so he was very angry. She wanted to sue the manufacturer. So do you think Mrs. Donald Hill could sue the manufacturer under contract law? Yes or no? Yes or no? Do you think she could sue the manufacturer under contract law? The answer is no. Very good. The answer is no. Why? Because there was no contract. There was no contract between Donald Hill and the cafe. Okay. Because the ginger beer was bought by Donald Hill's friend instead of Donald Hill. Okay. This is the reason. No contract. Okay. So she consulted the lawyer. The lawyer said you cannot sue by contract. You have no contract with the manufacturer. Okay. So of course, at the end of the day, Donald Hill decided to sue the manufacturer. It was a very big attempt. Because under the law at that time, the chance was very low. Okay. If the judge followed the law at that time, Donald Hill would certainly lose the case. Okay. She could not win. If the court, okay, so follow the current law. So she was only gamble. So she had made a lot of effort because she was living in somewhere near Glasgow, but she had to go to London at that time. The House of Law was in London. So Even nowadays, it will take you a very long time. You travel from Glasgow in Scotland and then to say London. It took you a lot of time. So you could imagine in the year 1932, it would take Donald much more time from Glasgow to London. Very funny. So plaintiff sued the defendant. The defendant was a manufacturer of the ginger beer for damages. And also facts were not disputed. What does it mean? What's meant by facts were not disputed? We have mentioned before. So for legal dispute, usually it's divided into dispute in fact and dispute in law. Okay. Most people only know dispute of fact. Because nowadays, for example, if you find some cockroach, you find decomposed nail in the food provided by the restaurant. Usually the restaurant will dispute the fact. The restaurant will say that, so the customer bought the cockroach, he put the cockroach in the congee, okay? So they would dispute the fact. Usually, in many cases, the plaintiff and the defendant will give two different stories. Okay? There are two versions of the fact. So we call it dispute of fact. Okay? For example, in a fighting case, usually both parties will put the blame on the other party. They will give you a different story. In divorce, is also the case. The husband will complain the wife will also complain the husband. So usually they will give two different stories. And also in so many cases, like a fighting case in the school, some dispute between brother and sister, usually they will give two different stories. But in the case of Donald Hill, there were no dispute of fact. The defendant Stevenson did not dispute the fact of the case. The manufacturer did not say, oh, that woman he bought the decomposed nail. So to the cafe, he put the decomposed nail in the bottle, okay? Because she wanted to get some compensation. So of course, when you are reading newspaper, you will find sometimes it will happen. Some people, so they bought something dirty in the food and try to claim get some compensation. They will complain to the restaurant or to MTLC because they just want to have a few $1,000s. Okay? Some people are so poor, they will be very happy if they can get a few $1,000s from the restaurant or the company. So sometimes you have to dispute the fact. We could not believe in the complainant or plaintiff. Okay? So if you are a lawyer, sometimes you also learn the truth. You find that the employer, employee, husband and wife, or creditor and debtor, okay, all of them, they will give a very different story. So because in this case, facts were not disputed. So we have to know we have dispute in fact and also dispute in law. Okay? In this case, we only have dispute in law. Why? One of the reasons is that the manufacturer, he was not worried about any possible liability. Because at that time, he will not be liable. If the court used the law at that time, used the law in 1932, the defendant would not be liable. Okay? So the court, so the case was heard in the House of Lords, the highest court in England. So for the court, they have two options: either to confirm the existing law following the current legal principle, or extend the law. Most judges will choose A, especially judges in the lower court. They just confirm the existing law. They just apply the legal principle to the case. Okay? Only judges in the higher court, usually it must be at least a court of appeal, or sometimes it's only the job is only done by the House of Lords. Usually only judges in the highest court will extend the law, develop the law, right? For judges in the lower court, they are not entitled to do so. Because these are the two choices open to the judge. Of course, everyone knows that the judge choose to extend the law instead of just confirm the law, just follow the law. Okay? Please answer. Please do the exercise on page 88. Please go to page 88. Sorry, I think. Please go to page. Sorry, it should be page 92. Page 92. Below that, so you can find the two different ratios given delivered by Lord Macmillan and also Lord Atkin. Okay? These are the two different ratios given by Lord Macmillan and Lord Atkin. Now you have to do an exercise and activity on page 91. So the purpose is to enable you to practice the application of law to solve legal problems. The fact pattern is that so a boy called Basil, he buy a t-shirt for his girlfriend Anna. The shirt were packed in a sealed black carton that could not be opened and inspected before purchase. Anna contracted dermatitis. Dermatitis is some kind of skin disease, 皮膚炎 from wearing the shirt. She was unable to work for 6 months. So the task is to consider whether the manufacturer of the t-shirt owed Anna a duty of care under Lord Macmillan's basil and also under Lord Atkin's basil. In this case, we have several judges. Two of them are Lord Macmillan and also Lord Atkin. They give two different ratios. So when you refer to the two different ratios of Lord Macmillan and Lord Atkin, there may be a different answer. Okay? Now please go to the ratio of the two judges and answer the question. Please go through the two different paragraphs and see whether so the manufacturer owe Anna a duty of care under the different ratio of the two judges. I'll give you 10 minutes time. Now please do this exercise. Li Yunqing said that fact is not the issue of the case. Sometimes we have issue of law, sometimes we have issue of fact, sometimes we have both. Okay? In some cases, but you must have this concept. You must have this concept. You have to distinguish issue of fact and issue of law. Okay? Don't think that all cases are related to issue of fact. In real practice, issue of fact may be more important than issue of law. It depends on what kind of case you are talking about. In some cases, for example, in fighting case, in many cases relating to politics. So from time to time, there are issue of fact. But in some cases like land law, usually it's on the issue of law instead of issue of fact. And also in this classroom, in the classroom, usually the main dispute is the major dispute is dispute of law. Okay, we have to study the law before we study the fact. Okay, so in the courtroom, so the dispute may be on fact issue. But in the classroom, usually we will assume all the facts. You have to assume all the facts are true. For example, in an assignment, we give you a lot of facts. So you have to assume all the facts are true. No need to dispute the fact. Your answer is based on the fact given. Okay. Why you cannot dispute the fact? Because if you dispute the fact, the answer will be totally different. Okay. So no the assignment will be meaningless. For example, we say, oh, John is 20 years old. You cannot say, oh, I don't know whether he's really 20 years old. So the answer must be based on the fact that John is 20 years old. You will dispute the fact, you will assume that he's only 5 years old. The answer will be totally different. So you have to assume all the facts given in the assignment to be true. Who cannot access to the who? There's still some student. So what I can do? Tone check in. What can I do now? I cannot see any request by student. There may be some technical mistake for Doris. Okay, so please do this exercise. Go through the two different paragraphs and find the answer. When you compare these two paragraphs, of course you can find the difference. There will be different answer for the same question. Okay, so we may now go through the answer. Under Lord Macmillan's Raceway, so do you think the manufacturer owe and duty of care. First of all, don't confuse the concept of duty of care and also liable. When you owe someone a duty of care, it does not mean that you are liable. These are two concepts. Duty of care is only say one of the elements. Altogether, we have three elements for negligence. Duty of care, breach of duty, and also causation. So duty of care is only one element. When you say someone owe a duty of care, it does not mean that he's liable. So, for example, a driver owe duty of care to all the passengers. 即係負上責任 ，OK？ So when someone owe a duty of care, it means that he has to exercise reasonable care. It does not necessarily mean that he is liable. So before the case of Donald Hill and Stevenson, usually the manufacturer did not owe any duty of care to the ultimate consumer. Because they only owe duty of care to the buyer under contract law, but in tort law, they did not owe any duty of care. But this case is a landmark case. Donald Hill and Stevenson established the doctrine of negligence. So before that, no one will be liable simply because he was negligent. But now, so even though you are only negligent, you are still liable. After the case of Donald Hill and Stevenson. Of course, this case was developing the law. So you find a big difference between the two judges. So Lord Millen, he was more conservative. When we say someone is more conservative, usually what does it mean? It means that, of course, he does not want to extend the law so quickly. He wanted to say restrict the ratio to a small extent. So you find that under Lord Macmillan's ratio, a person propagating engaged in the business of manufacturing article of food and drink intended for consumption by members of the public in the form in which he issued them. So that is the legal condition. You have to recall what you learned in chapter 1. So a legal rules, the structure of legal rule is just like a conditional statement. We have the legal condition and also the legal consequence. This one is the legal consequence. The legal consequence is that the manufacturer will be under a duty to take care in the manufacture of those articles. Is the consequence. So it's the condition. For the condition, it can be broken down into so many elements. Okay? Can you count how many of them? First of all, it must be for gain. For gain means that it's for profit. It means that if you produce food to your friend free of charge, if you make some, say, cookie for your friend, you make some cookie for your relative as gift. So it will not fall within this ratio. It must be for money, for gain. Engage in the business. So usually he's a manufacturer for commercial purpose, like say some food manufacturer like Maxim or Wingwa or some other manufacturer. They are engaged in the business of manufacturing articles for food and drink. Like White Soy, Coca-Cola. They are preparing drink intended for consumption by member of the public. All the food they produce for sale to the public. Okay? So they will be under duty to take care. For those manufacturers, they will be under duty to take care. So that the duty to take care is in a legal sense. It's not a moral sense. Morally, I think everyone should have a duty to take care towards other people. Morally, right? But legally speaking, it's the first time the court imposed such a duty on the manufacturer. Okay? This duty to take care. The duty to take care is in a legal sense instead of a moral sense. Okay? The later part is only to elaborate the duty. Okay? It's only to elaborate. Sometimes it's repetitive. So for this one is a little bit redundant. So the second part is a little bit redundant. So the second part, you can ignore the second part because the purpose of the second part is only to elaborate, to further elaborate the legal principle. But how about law action? Oh, sorry. How about lot acting? For lot acting, so do you think the ratio is wider or narrower? Manufacturer or product? Is it wider or narrower? When you compare the two different paragraphs, which one is wider? Wider, very good. Because it's not confined to food and drink. Of course, everyone knows that food and drink is more sensitive. Because if the food and drink is poisonous, is unhealthy, it will bring a lot of say harm to the buyer. Okay, so for Lord Macmillan, he was only ready to impose a duty on manufacturer of food and drink. So the consequence will be more serious. So it's the reason why he would like to confine the duty to manufacturer of food and drink, because they are more sensitive. Okay, but for other products, they won't be so sensitive, like say a plastic bag or a pencil or ball pen. They won't be so dangerous when compared for the food and drink. But Lord Atkin is ready to impose the duty on all the product. So no, the duty is not confined to food and drink, which is sell in such a form as so that he intend to reach the ultimate consumer. So it's very extensive. All the product may reach the ultimate consumer, and also in the form in which they left him with no reasonable possibility of intermediate examination. Of course, nowadays, so if you go to the market, you can always examine the product. Like for example, you buy some no vegetable, you buy potato, you buy tomato. Of course, you can examine them. But if you go to supermarket, so many things, so no, they cannot be examined. So many things are in the box. You are not allowed to open those box. Okay. So the pair, you cannot see the product inside. You can only sometimes you are only shown a sample. You can see the sample. For electrical appliances, you can still use the sample. You can test the sample, but you are not allowed to see the product you buy because it's in a box. Okay. So for those products, so for the manufacturer of those products, so they will owe duty of care. Okay, with the knowledge that the absence of reasonable care, so it will result in an injury to the consumer's life or property. Under such circumstances, these are the legal conditions. So for this part is the legal condition. This part is the legal consequence. So if you can fulfill all those elements, so the manufacturer will owe a duty to the consumer to take that reasonable care. So this one is more extensive. It's wider when compared with Lord Macmillan's case. So the manufacturer of the T-shirt, so you see that manufacturer of a shirt, if we use Lord Macmillan's ratio, what is the outcome? So does he owe any duty of care under Lord Macmillan's ratio? Yes or no? The answer will be no. Because the T-shirt was not food and drink. Okay? The duty only applied to manufacturer of food and drink. So the T-shirt does not fall within food and drink. Okay? So the manufacturer of T-shirt will not owe any duty of care if we follow Lord Macmillan's ratio. How about Lord Atkin's ratio? The answer would be yes or no. Very good. The answer would be yes. Okay? Because you don't have to be manufacturer of food and drink, so it applies to all products. The only requirement is that so it's in a form in which they left him with no reasonable possibility of intermediate examination. If you buy a bottle of ginger beer, can you examine the ginger beer? When you buy the ginger beer, it's not something possible. You buy a bottle of Coca-Cola, Pepsi-Cola, or white soy, or orange juice, usually you are not allowed to examine the product. You can open and then examine the product and say, oh, I don't want to buy it. So of course, it's totally unacceptable. So you can the manufacturer of the T-shirt has fulfilled all the requirement under Lord Atkins ratio. Okay? So the answer will be totally right. So when you compare the two different ratios, you find that Lord Macmillan was more conservative. He did not want to extend the duty to impose the duty to so many people. I just want to confine it to food and drink. But for Lord Atkins, he would extend the duty of care to the manufacturer or so many products. Right? Okay, now please take a break for 10 minutes and then we will continue your lecture after the break. Please take a break. We will so we'll continue. Of course, we will follow Lord Atkins' ratio. I think Lord Macmillan. So he's one of the. In this case, so we will follow Lord Atkins' ratio. Lord Macmillan's ratio is no longer applicable. Now we'll continue the lecture. For this case, we can learn so many things. And also we have a legal concept called cause of action. Cause of action is a quite important concept in civil law. Cause of action, so it will affect whether you can sue someone. If you want to sue someone under civil law, usually you must have a cause of action. So in criminal law, someone must be guilty of some criminal offense. Okay? So even though someone has done something bad, but if it does not amount to a criminal offense, he will not be prosecuted. He must be guilty of some criminal offense, so he has done something which amount to a criminal offense. No, before that he can be so that he can be prosecuted. In civil law, whether someone will be sued, it depends on whether the plaintiff has any cause of action. The question is, could the claimant or the plaintiff sue the manufacturer? The claimant had to prove that there was a legal ground justifying an order compelling the defendant manufacturer to pay damages. So it's called cause of action. For example, if someone is impolite to you, usually you cannot sue. You cannot sue him because there's no such cause of action. Okay? But if you have signed a contract with someone, so the other party does not perform the contract, you can always sue him for breach of contract. Breach of contract is a cause of action. Being impolite to other people is not cause of action. It means that factual circumstances which, if proved, entitle the plaintiff to the remedy or relief claim. Okay, that's a claim which is proved by legally acceptable means. The verifying cause of action in the case of Donald Hill and Stevenson was liability under the tort of negligence. Negligence is one of the torts. For tort law, is mainly classified into intentional tort and also negligence. If the defendant commit the tort intentionally, it's called intentional tort. Okay? So if he only did it negligently, so we call it negligence. Negligence is still liable. From time to time, we always say, "Oh, I'm only careless." So I should be excused. In social life, is okay. You step on other people's foot carelessly. Usually, you just apologize. Oh, sorry. So no, the other party, no, usually he will excuse you. He will forgive you. Say when you apologize. But in law, so if someone is negligent, he will be liable. He cannot just apologize. Because something may be very serious, like some traffic accident. The victim may suffer from very substantial injury. The element. So we will learn more in tort law. These are the three elements of negligence: duty to take care, failure in that duty, breach of duty, and then causing damage. We call it duty of care, breach of duty, and also causation. So many, I think many years ago, I know that it was a question for the admission examination of a kindergarten or primary school. I don't know. Some primary school in the entrance examination. So they asked the question, "Oh, what are the element of negligence?" So no, these are the answer to that question. So for primary 1 student. These are the three elements. So we will examine these three elements in the module of obligation 2. So module 3 are obligation. We have obligation 1, that is contract law, and also obligation 2, that is tort law. The legal issue is whether the manufacturer is under any legal duty to the ultimate purchaser or consumer. Because for the ultimate purchaser or consumer, sometimes they are not the other party to the contract. But the manufacturer, usually he will sell the goods to the say no wholesaler or retailer, is unusual for manufacturer to sell the goods directly to the ultimate consumer or purchaser. But of course nowadays would say I think with the internet is still something possible. It's possible. Many people they will buy the goods directly from the manufacturer nowadays. Taobao, okay. So for a lot of sale through the internet is something possible. Manufacturer they have some retail department. They will sell the goods directly to the purchaser or consumer through the internet. Is something possible. But in the past, usually they will sell the goods to the wholesaler, and then the wholesaler will sell the goods to the retailer, and then the retailer will sell the goods to the individual purchaser. And the purchaser will also pass the goods to the family member, friend. So for example, if you go to supermarket, you buy a lot of food. You will not consume all the food by yourself. Sometimes you hold a party, Christmas party or birthday party. You invite so many of your friends to come. So they will consume the food, but they are not the buyer. Okay, they did not buy the goods. They did not buy the food from the supermarket. Okay, so it was bought by you. But the ultimate purchaser may be your friend, okay, or your relative. The outcome is by majority feel to allow the appeal. The whole formulation of the ratio didnt are relevant for purpose. One stated by Lord Macmillan and the other by Lord Atkin. The activity is something we have done before. The decision, decision is important to the party to the legal action. The decision, the outcome of the judge is important to the party. For the party, they are usually only concerned with the decision. When someone is prosecuted, his main concern is whether he's found guilty or not guilty. Okay? So he does not care too much about the reasoning. But for ratio, it's important to law student, lawyer, and also legal scholar. When we study the case, we are not so concerned with the outcome. Whether the defendant is found guilty or not guilty is not something so important to us. The more important thing is the reasoning, the legal reasoning, the underlying principle, the ratio, which is something much more important than the outcome of a case. For the doctrine of precedent, we have learned the doctrine of precedent. So lower court is bound by the decision of high court. For court, usually it will follow its own case. So of course, for this system don't think that it's easy. So don't think that it's easy to build up this doctrine of precedent. You need so many things. Okay? So for the judge, they must have good mastery. They can master the language very well, especially for the laws in English. It means that all the judges, lawyers, they must have good command in English. We have a system of law report, and also we have a court hierarchy, and also we have to respect the law, respect the precedent. Okay? So it's the reason why this system can work. So to summarize, we can say that the advantages of the doctrine of precedent is that the legal position is very certain. Okay? You can ascertain the law more easily. By some legal research, you can ascertain the law. So you will be very clear of the legal position, the legal principle. You can predict the outcome when a case is heard before the court. If the issue is issue of law, so you can predict the outcome more easily. And also the decision, they are consistent. So even though this case was heard by Judge Wong, that case was heard by Judge Chen, another case was heard by Judge Lee, they're supposed to be consistent. Okay? The court, even though by different judges, so they will make consistent decision. And also it will not exclude any development. So the court can still develop the law. The development will be very orderly, very stable. Okay, so of course we can say that it's very slow. Okay, is a foundation for the orderly development of law. Because the higher court, usually the highest court can develop the law. In England, it should be the House of Lords and also Court of Appeal. In Hong Kong, it's the CFA and also CAR. They can develop the law. Usually, they are in a better position to develop the law. But the disadvantage is that there will be injustice. So sometimes it cannot keep up with the development of the society. The society has changed so much, but the common law is not ready to change so quickly to keep up with the development of the society. Sometimes it will also impede the development of the law. For junior judges, even though they want to develop the law, they are not allowed to do so. They are bound by precedent made by the higher court. Okay? So it's one of the disadvantages of this system. And also, judges usually they are bound by precedent. They don't have sufficient flexibility. Okay? So they cannot make a very fair decision. So it's one of the limitations of the doctrine of precedent. Cause of action. So if you want to sue someone under civil law, you must have a cause of action. It must be recognized by law. You cannot just say suggest any cause of action by yourself. For example, a breach of contract, so negligence, defamation, all of them cause of action recognized by law. Okay? You cannot just say, oh, you are doing something improper, you are misbehaved, so you have a very bad behavior, very bad habit. They are not causes of action. They are not something recognized by law. Can you sue someone simply because he's not so polite to you? Can you sue someone because he's not so kind to you? When you sue someone simply because he has just forgot what you have done for him. So all of them are not cause of action. Cause of action must be recognized by law. Okay? So and also it's something defined by law. So you have to fulfill all the requirements. You have to find all the elements of the cause of action, just like all the elements of a criminal offense. Right? And now we go back to what we have missed. So it's the part on obiter. Now we go back to slide 6. So in the answer, we have another concept called obiter. Obiter, the singular is obiter dictum. The obiter dicta is the plural. So obiter is in contrast with ratio desidenta. Both of them are statement of law, but ratio is the reason for the decision. So it's an underlying principle for the decision or case. But obiter, so it's not related to the decision. It's a statement of law that was not necessary to the decision in the case. Why? Why obiter is still why we have obiter? Because so for the judge, they are very knowledgeable, just like a professor or lecturer or teacher. So I think it's experience all of us have encountered. So when you were in the secondary school, the teacher will tell you something outside the syllabus. For example, a teacher teaching Chinese literature, he will tell you something about politics, he will tell you something about history, he will tell you something about life experience. So these are useful, but they are not relevant to the syllabus. So the judge will also do the same, because judge is a very knowledgeable person. Sometimes he want to express his opinion, even though the opinion is not directly relevant to the case. The decision of the court on the issue before it would be the same without this statement. Okay? So of course we can, for example, magistrate court, he says something about dog, so it's something irrelevant to the decision, but it is still regarded as an obiter. Sometimes obiter is useful. Okay. So there are some examples of obiter, like statement of law based on fact proof or as found by which were not the basis for the decision. It's irrelevant to the decision, or something immaterial to the decision, or is statement of law about fact law proof or found, or fact law determined. Sometimes people don't think that the judge can prove all the facts relevant to the case. There are some maybe some facts which are not proof. Even though we have investigation, I don't think that the investigator can find out all the relevant facts. Some facts are not cannot be proved. Some facts cannot be found. Okay. Dicta, so obiter, they are not binding but only persuasive. It's still useful, even though it's not binding. I don't think that say a case, when a case is not binding, it will not be meaningful. So it's not the case. For many cases, even though they may not be binding, but they are highly persuasive. When a case is highly persuasive, it's nearly the same as a binding case, because most judges will follow the case. For example, in a case called Hepburn, Hepburn is a leading case for negligent misstatement. It's in 1964. It's the landmark case for negligent misstatement. So nowadays, if you make some statement carelessly, you may be liable. It's called negligent misstatement. In this case, all the judges agree with Lord Denning's Judge Lord Denning. No, in Chandler's case, I think it's the obiter of Lord Denning in a case called Chandler. That should be liability for negligent misstatement causing loss. So it means that before the case of Hepburn, this case has established the doctrine of negligent misstatement. But before the case, in 1964, there was already some cases with obiter to suggest that negligent misstatement, there should be liability. It means that if you make some negligent misstatement, you should be liable. It means that you have to exercise reasonable care when you are making statement. Okay? So when you are asked to provide information or opinion, you have to be careful. Otherwise, you will be sued because you will be liable. So the question is, how can we determine whether a statement of law is au dictum or racial? The job is to be done by the later judge. When a case is cited before the judge of an instant case, he has to decide whether this statement is dictum or racial. How can a judge of a previous case avoid the judge of a later case to think the statement of law is only a dictum? So he has to make it very clear in the judgment. By basing his conclusion on that statement of law, he has to make it very clear that the decision of the case is based on that statement. So the statement will be regarded as racial instead of obiter. And also we have a concept called overruling. Many students have confused the concept of overruling with reversion. So the meaning of overruling is that it means when a later court declared that the legal principle in an earlier case was wrong. Overruled cases, the significance is that if a case is already overruled, it cannot be used as a legal authority. It means that the lawyer cannot cite this case anymore. And also only a court at a higher level in the judicial hierarchy can overrule a person. Only CFA can overrule a CA case. Only CFA and CA can overrule a CFI case. CFI cannot overrule its own case. CFI can choose not to follow. Don't confuse not to follow with overrule. These are two different concepts. So you can choose not to follow, but you cannot overrule. CFI can choose not to follow its own case, but CFI cannot overrule a CFI case. Only CA and CFA can overrule a CFI case. But overruling is something more serious than not to follow a case. Just like the case. So you can choose not to follow your colleague's advice, but you cannot overrule your colleague's decision. Okay? Because you are not a senior. You are at the same level with your colleague. Okay? For example, so you are an assistant manager. Another assistant manager has made a decision. You can choose not to follow, but you cannot overrule his decision because you are not senior than him. Only the manager can overrule the decision of an assistant manager. Okay? So you are only an assistant manager. You are not in a position to overrule the decision of an assistant manager. Reversing means to allow the appeal. It means the high court setting aside the judgment of a lower court in the same case. Okay? For example, if someone loses in the CFI, he appeal to the CA. CA may reverse the decision of the CFI. Okay? When the high court reverses the decision of the lower court, it means that the appeal is allowed. 即係上訴得直啊。So don't confuse reversing with overruling. There are two different concepts. Reversing only means that the higher court changed the decision made by the lower court. But for overruling, it means that the higher court declared that the decision made by a lower court is incorrect. So it's something much more serious. If the lower court bases its decision on an earlier decision, the appeal court may decide to overrule that earlier decision as being wrong in law. So if the lower court, for example, if CFI has made a decision based on a precedent case in 1970, when the case is appealed, the CA can also overrule that earlier decision. Okay. We can use for reversing. We can use a simple example of a legal action between a very famous lady. Do you know the name of that lady? Anyone know the name of that lady? Oh, that beautiful lady. Which one? Xiu Tim Tim. It's Lina Wang. Lina Wang. Her former name. Kong Yu Sam, Gong Yu Sam. In fact, her English name should be Lina Wang. Lina Wang was the formal name of that lady. So if a woman is married, sometimes some lady would use the surname of her husband. Okay. It's also very funny. So if a woman get married with a British, he will use the surname. Okay. For example, if May Wong get married with Mr. Thomas, May will become May Thomas. So sometimes people may not know she's Chinese. So some people will think, oh, she must be a British. In fact, she's Chinese. So for this case, so see that say at the very beginning, so the case was heard in CFI. Okay, so the case was between Lina Wang, her father-in-law, 佢個即係家公okay. So no, that gentleman was the father of Mr. Wang Tefei, okay, 黃德輝個爸爸 okay. So there was a dispute about the will. The will there was a will left by Mr. Wang. So no, they have dispute on this issue. So in CFI, who won the case? It was the old Mr. Wang. Old Mr. Wang had won the case in CFI. Of course, Lina Wang appealed. Okay, Lina Wang appealed to the CA. To CA. Again, who won the case? Again, the old Mr. Wang. Old Mr. Wang. So Lina Wang further appealed to CFI. CFA. Who won the case? So it was Mr. Wang, Lina Wang. So Lina Wang won at the end of the day. The decision made by CA was reversed by CFA. So we call it reversing. The appeal was allowed. The decision made by CA was reversed by CFA. I see, even though the old Mr. Wang won 2 times, so Lina Wang was the final winner. He was the final winner. He got all the money, right? So it's also the reason why we have Mr. Chen Chun Chung. So Lina Wang lose the case. Mr. Chen will not be found guilty. Distinguishing is a legal concept. It means that you have to distinguish the instant case from the precedent case. So when the judge is hearing a case, when the lawyer say a precedent, the lawyer say that Justice Wong, so under this case so and so. So if you don't want to follow that case, so what should you do? So one of the solutions is to distinguish. The judge will say, oh, sorry, these two cases are not similar. So we should not follow that case. Their two cases are different. Okay. How about the question is, how about if the judge does not want to follow a precedent? One of the solutions is to avoid an inconvenient precedent. Inconvenient means that you don't like it. You don't like that precedent. You don't want to follow the precedent, but you are bound by the precedent. So what can you do? The only thing that you can do is to distinguish. It means that they are different. Okay. The situation is different. The two cases are different. The two different scenarios are different. Distinguish the case on its fact, or by stating that it was not a decision of law but a decision of fact. So at the end of the day, you don't want to follow. You just argue that the two cases are different. Okay? The fact of the instant case are material different from the facts of the precedent case. These are the possible arguments. Right? That's all for chapter 7. Please do the revision question before we proceed to chapter 6. So now is the end of chapter 5. Okay. Please do the revision question, filling in the blank and so MC before we proceed to chapter 6. Okay, so you are going to do the revision question. Please do the revision question. So on slide 22. Slide 22. Slide 22, 23, and also 24. Okay, so we can just go through the answer. Okay, for number one, so ratio decision is the principle underlying the decision. So we always say that is the say reason for the decision, the underlying principle. So number two, the ratio is expressed as a statement of law. A statement of law. Okay, usually it's a general principle. If it can be used in the future in other similar cases, it can be applied to many other cases. So and also it's at a higher level of generality. So for example, in the case of Donald and Stevenson, the duty is not confined to manufacture of ginger beer. So the duty is applied to so many manufacturer or product. So it will be more extensive than the fact of the particular case. Another obiter dicta is the statement law that was not necessary to the decision or case. So it's something less important than the ratio. So when we say we follow a case, when a case is binding, it only means that the ratio of the case is binding. The obiter of a binding precedent will not be binding on the lower court. Only the ratio is binding. The obiter is not binding. It's only persuasive. So number 4, overruling means that the later court declared that the legal principle in the earlier case was wrong. For example, the instant case is in CFA when the lawyers say a CFI case in the year of 2000. So the judge in the CFA may declare that the legal principle in the CFI case was wrong. So when a case was overruled, it can never be cited again. So it would be a disaster if a lawyer say a case which has been just overruled. It will be a serious mistake for the lawyer. So if he cite a case which has already been overruled, he will be heavily criticized by the judge. Number 5, reversing means that the High Court setting aside the judgment. So it's equivalent to allow an appeal. MC, which one is not advantage or precedent? So this we see convenience for judges. Okay. So number 2, which one is a disadvantage? Right. So we can say that. So it should be 1 to 3. Okay, 1 to 3. It should be B. 1 to 3. How can we determine whether a statement is dictum or not? The job is done by the later judge. Should be B. Okay. What can the judge or the lower court do if he does not want to follow a binding precedent? So if the instant case is in CFI, if the lawyer say a CA case, by vertical stare decisis, the judge has to follow that case. If he does not want to follow, he can distinguish. I can argue that the two cases are different. They are not the same. They are not similar. Okay? This is the reason why he can choose not to follow. Very good. So now we can go to chapter 6. I will now go to chapter 6. Chapter 6 is about legislation, okay? So it means the law passed by the legislature. So in Hong Kong, it's the Legislative Council. So altogether, we have 2 main parts of this chapter. The first one is a minor one. It's called making of legislation or passing of legislation. It's a quite dry and boring topic. So very mechanical. I think many of you will have some knowledge when you were in secondary school in general study or economic and public affairs. We will talk about the process of legislation. The second part will be much more interesting and also more difficult. It's called interpretation of legislation. It means how does the judge interpret the legislation. But from time to time, there will be ambiguity or uncertainty of the legislation, even though it's so well written. So it has been examined by so many people, but there are still some ambiguity. Okay? So the judge has to interpret the legislation. 釋法 okay? 譬如說 don't think that only the MPCSC will interpret the law. In fact, MPCSC, of course, they will only interpret the basic law in Hong Kong. So they will not interpret other ordinance. For interpretation of law legislation, the job will be done by the court instead of the MPCSC. The legislative process, so we can go through it very quickly. Legislative process, so is the process of the government. So we have 3 different say power. So we have separation of power, even though the government denied that we have separation of power. So we have legislative, executive, and also judicial. So in the next chapter will be the judicial process. So chapter 7. Of course, we won't cover too much about the executive process. So we only focus on legislative and also judicial process. The ordinance, so the main body of the legislation is called ordinance. So under the ordinance, we have a lot of subsidiary legislation. But for the legislative process, we only focus on the ordinance. Ordinance will start from a bill. Bill is a proposed legislation which has been drafted and introduced into the legislative system, but not yet enacted. Usually the job is done by the government. Okay, so it's very different from many countries. For so many countries, the job of drafting legislation is by the parliament. The parliament will draft the legislation. But in Hong Kong, drafting is still by the government, the DOJ. This is the law drafting division of the Department of Justice. Process of legislation. So to summarize, we can say that drafting bill, and also it will post a notice of intention to present a bill, and then present the bill and publish the bill. Usually is in the Gazette. The presentation and publication of bill is on the Gazette. So Gazette is the is a publication by the government. So for all the ordinance, bill, and also subsidiary legislation, together with some other notice, like legal notice or tender auction or something like that. So the publication is called Gazette. Then will be free reading. Full the legislative passing of bill, full legislative will be first reading, second reading, and also third reading. 三讀通過. And then after the third reading, the chief executive will sign on the bill and promulgate the bill. It's called the chief executive signature and promulgation. Legally speaking, the chief executive can refuse to sign on the bill passed by the legislature. It means that before 1997, the governor also had the similar authority. We just follow the law before 1997. But this authority was only exercised once by the governor so many years ago. I think in the 19th century. I think the authority to refuse to sign on the bill it had never been exercised by any governor before 1997 in the 20th century. I think only in the 19th century. Okay, so there will be this kind of incident. And then there will be commencement date for the ordinance after it has been passed. In the past, so as long as the bill has been passed by legislature, it will come. The commencement will be immediate. But now, many ordinances, they will have different commencement date. Many ordinances has already been enacted, but the commencement date may be 1 year later or several months later. Because the government always want the public to have more grace period to adjust to the change, right? It's the reason why for many ordinances, they will have different commencement date. Sometimes the commencement day is to be appointed by the governor. And also report to the Standing Committee of the National People's Congress. For this step, it's very disputable. Most of the legal scholars in Hong Kong think that it's only a formality, but the Chinese side always think that it's subject to the consent of the Standing Committee of the National People's Congress. The NPCSC can always veto the new legislation. It's the standpoint or opinion of many legal scholars in mainland China. But most of the Hong Kong legal scholars think that it's only a formality. 呢個只係一個形式中國嘅學者認為咧係可以否決嘅。But it is something disputable. So I think it's very unlikely for any legislation the Chinese government does not like will be passed in legislature. Because we have so many government legislative council. So it's not something possible. So we don't have any incident. So when the Chinese government want to veto those legislation which has been passed in the legislative council, or maybe they want to reserve the right. Maybe in the future, if all the councillor against a local government, they will pass some legislation which the Chinese government does not like. So they will veto the new legislation. But it has never been exercised. So this point is not something so important. And then we have the delegated legislation. So under the main ordinance, we have many regulation, many subsidiary legislation. They have different name. So the delegated legislation. Why is called delegated legislation? Because so only the legislative council has the authority to pass legislation. But for legislative councillors, usually they are very busy. So and also they are not expert in so many technical issues. For example, we have the company ordinance, but under the company ordinance there are lots of regulation. So who will prepare the regulation? Usually is the company registry. The company registry officer, they're expert in company matter. So they are in a better position to prepare the regulation. So it's the reason why we call it delegated. Because the authority to pass legislation is delegated to the government department. Because presumably only the legislative councillor will have the authority to enact legislation. But now this authority has been delegated to the government department. Okay. So it's the reason why it's called delegated. Also it's subsidiary or subordinate. Because it's under the main ordinance. So it's called subordinate or subsidiary. Also they have different name. They may be called proclamation, rule, regulation, all the rest of it. But the most usual one is bylaw. Bylaw and also regulation. These are the two most usual name for those delegated legislation. Power to make delegated legislation is conferred most often on executive officer, like people in the policy bureau, 政策局 and also government department like the company registry, say labor department, fire service department, police, etc. Frequently the chief executive council, there's the executive council, and also sometimes an outside body like the SFC, or a state agent, authority, or even judge. So later I will show you some delegated legislation by judges. So for legislation, it's the second major source of law in Hong Kong. So we have two categories. The constitutional provision, that's the basic law. Basic law is a separate topic, very important topic. So we have a separate module to cover basic law. And so we have the local legislation. Why those ordinances are called local legislation? 本地立法 why it's called local? Because it's made in Hong Kong. The basic law is not made in Hong Kong. It's made in Beijing. So for ordinance, like the company ordinance is made in Hong Kong. So it's called it's subdivided into primary legislation. Usually means ordinance. For subsidiary legislation, they're called secondary or delegated legislation. Procedure are quite straightforward. Okay, we may just go through the workbook. Now we may go to page 99 to 102 of the workbook. Page 99. So we start with a bill. A bill is the draft legislation. Usually it will be amended, especially for more serious bill. Usually there will be a lot of amendment, drafting bill, notice of intention to present bill, presentation and publication of bill, passage of bill, Okay, and then so we are free reading, chief executive signature, commencement, reporting to the standing committee. So the workbook does not mention whether it's only a formality or a serious procedure, whether the MPCSC can veto the legislation. So I think for Hong Kong legal scholar, they think that it's only a formality. So it's reporting for record purpose. It's not for approval purpose. And also the MPCSC has never vetoed any legislation passed in Hong Kong. Just as supplementary information, all the law in China, in mainland China, we have so many provinces, so many county, city. Usually, after they have passed any legislation, they have to report to the Standing Committee of the National People's Congress. Mainly is for record purpose. It will be very impractical for the MPCSC to veto those legislation. Okay? Because once they are passed, they have already been used. If the MPCSC say that, oh no, this legislation is ineffective, it will cause a lot of confusion to the people in a certain region. Also, I can show you some of the important example of subsidiary legislation. Okay, so example, so in this slide, we can show you the Mass Transit Railway bylaw. Usually, the bylaw has a capital letter. For example, this bylaw is under Chapter 556. That's the Mass Transit Railway Ordinance. So the chapter number is 556, capital B. This one is Chapter 6. Chapter 4, capital A. This one is Chapter 374, capital B. Okay. So I can show you the example. This one is the Chapter 556, Mass Transit Railway Ordinance. This one is the most famous bylaw among all the citizens. I think nearly all the citizens have heard of this bylaw. 地下鐵路嘅附例So I think most citizens in Hong Kong have heard of this bylaw because you regulate the behavior or passenger of the MTR. Okay. For example, there are lots of prohibition. For example, you cannot play any musical instrument. You cannot eat inside the car, say etc. So these are the most well-known bylaw. A failure to pay fare, you will be punished. So why you, for example, if you have done something wrong in the shop, you won't be punished. The shop cannot punish you. The shop can only ask you to leave or sue you to get compensation. But why the MTLC can impose fine on you is because of the bylaw. Why the MTLC can punish you when you breach the bylaw? Why? Because it's the law. It's the bylaw. It's legislation. For if you go to a shop, the shop cannot punish you. The shop has no such authority. There's no bylaw in the shopping market. But if you take the MTR, so there will be say bylaw. The bylaw can impose punishment on the passenger. If they do not obey the bylaw, they will be punished. For example, if you damage a ticket, you have to pay compensation. It's under the bylaw. Conduct of passenger, so there will be smoking is not allowed. You cannot cause any fire hazard. So spitting is also prohibited. You breach the bylaw, you may be punished. Right? Rules of the High Court is the very important rules for lawyer. All the lawyer they have to be very familiar with this rule. It's called Rule of the High Court. In the past, it was called Rule of the Supreme Court. Now it's called Rule of the High Court. Okay? You can go to chapter 4. Go to chapter 4. For example, this one. Chapter 4 is the High Court Ordinance. It's the High Court Ordinance. So chapter 4 of the laws of Hong Kong is the High Court Ordinance. Under the High Court Ordinance, you can find lots of rules. The most important one is the rules of the High Court. This one is very long, very long. So there are altogether so many orders in this rule. If you want to be a lawyer, you have to be very familiar with the rules of the High Court. Okay? This one is very long. Right? It's the procedure, this court procedure of the High Court. All the litigation lawyers, they have to be very familiar with these rules of the High Court. Okay. Now we have already finished the first part of chapter 6. This one is very mechanical and also a little bit dry and boring. Because it's quite easy, and also you don't need to know the detail. You want to know more about legislation, you can always go to the website of the LegCo. You can find a database for say bill, and also you can find a database for Hansard. Hansard is the meeting record. For the meeting in the LegCo, there will be a lot of record. The officer responsible for taking down the say the record for the discussion, etc. So you can find those record of the meeting. But in the next lesson, we'll go to a more challenging topic. This interpretation of legislation. Okay. From time to time there will be ambiguity, certainty, uncertainty of the legislation. So the judge has to interpret the legislation. Interpret is to explain the meaning, the proper meaning of the legislation. Okay. So it will be a much more difficult topic. Please attend the lesson. This Thursday. So we will tell you, we will explain to you the different approach used by the court. Altogether, we have 4 different approaches under the common law. So we will explain to you one by one. Usually, we have to use cases to illustrate those different approaches in interpretation. Okay? Thank you very much for attending the lecture. So if you have any difficulty, please know about 599G. 599G is more important now. Please thank you very much for coming. Especially your your participation in the lecture. I'll try to answer your question. Okay. As far as possible. Transition. What's the meaning of remedy and relief? They are more or less the same. I can tell you. Remedy is a more legal term. Remedy is a more legal term. Relief is I think is less professional jargon. It's less professional. Sorry, I know I forgot to share the PowerPoint. For a few minutes. Right? Can a lower court judgment be cited after reversing by High Court? I think of course it's possible, but practically speaking, I think usually you will follow the decision of the High Court. If you just say a lower court judgment which has already been reversed, I think it will be meaningless. I think in practice, no one will use this judgment again. Okay, wholesale thing, airport authority bylaw is also important. Because many, many public organizations, they have the bylaw, especially if an organization is managing a certain place, usually they need the bylaw to regulate the behavior of those users. For example, a tram company, bus company, etc., etc. Okay. Oh, I think for a channel comment, I do think the assignment of legal system. So I will cover this assignment maybe I think in lesson 7. So in the next lesson we'll cover the topic of the chapter 6, and then we'll go to chapter 7. 通出現啊 ，hurry up 啊！Scott Ricky Paul, I think you have some misunderstanding. For A, the sentence, the two different sentences are made by the same magistrate. There are not two different magistrates. So B is two different magistrates. So Scott, every problem. So you mean the gag? Gentlemen, you mean the gag? I think it depends. If you would like it, I will post it in so. Okay, because it's something quite informal. Okay. If you like it, I can post it in so. I'll try to make it more interesting. So usually I have to devote some time and energy. So in preparing those material. Thank you very much. So we'll end the lecture now. So